Hello and welcome to the new episode of series on the white collar crimes. This is Dr. Arjun Chowdhury. Today I am going to speak about a very sensational topic under the PMLA Act, that is attachment of properties. We all know that right to property is a constitutional right. Whenever the Enforcement Directorate proposes to seize or attach the property of an accused person, definitely the constitutional right of a person is going to be hampered somewhere. So we need to understand what are the intricacies in the PMLA Act and how the entire attachment proceedings are being done by the Enforcement Directorate, as well as what are the remedies of the accused person to save their properties from the Enforcement Directorate receives any information of money laundering from any investigating agency, be it the Central Bureau of Investigation, be it the Directorate of Revenue Intelligence, or even the State Police. So the very first thing the ED does is registering an enforcement case information report, which is equivalent to the FIR registered by the police or by the CBI. So after the ECIR, that is the enforcement case information report, is registered by the ED, the very next step is the ED summons the person, the accused person, for recording their statements and for production of any document which is relevant to the facts of the case. So after sending the summons to the accused person and after recording their statements as well as perusing the documents produced by them, if the ED is of the opinion that the accused person is possessing proceeds of crime, then they have the power to attach the proceeds of crime by issuing a provisionally attachment order. Please note that the provisional attachment order is valid only for a period of 180 days. So after the provisional attachment is done by the Enforcement Directorate, the original complaint, that is the ECIR, is forwarded to the Adjudicating Authority. So the Adjudicating Authority, after receiving the original complaint, if is of the prima facie opinion that the accused person is in possession of proceeds of crime and the attached property is indeed proceeds of crime, they will issue a show cause notice under Section 8 of the PMLA Act to the accused person to come and defend as to why the attached property shall not be confiscated to the government. So after hearing the accused person, if the Adjudicating Authority finds that the attached property is proceeds of crime, then the Adjudicating Authority will pass an order, thereby confirming the attachment made by the Enforcement Directorate. And once the confirmation order is passed by the Adjudicating Authority, the ED will thereafter take physical possession of the attached property. So once an order of confirmation of attachment is passed by the Adjudicating Authority, there is a remedy of appeal under Section 26 of the PMLA Act, which will lie before the Appellate Authority. If the Appellate Authority also confirms the order of confirmation of attachment, then an appeal will lie before the Hon'ble High Court under Section 42 of the PMLA Act. And as per the general recourse, we all know that if the High Court also confirms, the said order can be challenged before the Supreme Court. So is that the only thing under the PMLA Act regarding the attachment and confirmation of attachment of the property? No. The ultimate decision of confiscation of property depends on the special court. So if the special court acquits the accused person in the main PMLA offence, then the property will be released. But if he is convicted in the PMLA offence, then the attached property will finally be confiscated to the government. So these are the steps provided under the law with regard to attachment of property, proceeds of crime, and finally confiscation of proceeds of crime. Please stay tuned for more such discussions on remedies to counter attachment proceedings before the Hon'ble High Court and Supreme Court. That's all for today. Thank you.